All right, it's go time. Hi, folks. Question. How many of you have a clear plan as to what will happen with all your possessions if you were to suddenly leave this world today? That's exactly what we'll be discussing tonight at length. Our topic for this webinar is understanding, or let's call it demystifying, estate planning. And I'm your host, Brian Dougherty from Plc Financial Solutions, located in Fort Washington, PA, along with my beautiful, wonderful partner in business and life, Rachel Dougherty. Say hi, Rachel. Rachel? Oh, I think she's getting dinner ready. Anyway, she's going to be our moderator for tonight. She's handling the chat and Q&A boxes, and I'm going to explain what that is in just a minute. Plus, we have a very special co-host back again with us tonight. Her name is Rosemary Durkin, and she's an estate attorney from the very popular local law firm of Stark & Stark, located in Lawrenceville, New Jersey. But they also have offices in Yardley, PA, Marlington, New Jersey, and on Broad Street in Philadelphia. She's been practicing law for 40 years and has been with Stark & Stark since 1999. How you doing tonight, Rosemary?
Good. Glad to be here, Brian. Thank you.
I have to tell you, I'm excited to have you back. Last time, I guess we could kind of say we're back by popular demand with this topic, because we had an overwhelming response that time and this time, but we had all those technical issues last time, so we wanted to do it all again. So thanks for coming back on with us.
Sure, no problem.
But before we get started, let's take care of some general housekeeping first. So if your screen is not big enough, if it's not big enough for you, just move your cursor around and you'll see at the top of the screen, little black box with white lettering says view options. Click on that. It'll have a drop down. You can move to the right and you can make it larger if you want to. The next thing is you're going to also see, if you move your cursor around, there are some boxes at the bottom of your page. One, it's called chat, and that's what we're going to use for any comments that you might have. And also the other is called Q&A, and that's of course for any questions. So please use them accordingly, and Rachel will definitely respond to them in kind. Now, third one is I'm sure that many of you have many questions about the material we're going to cover today. And, since we have a good bit of material to cover and only an hour to cover it, I'm going to ask you to put your comments and questions into those boxes below. And at the end, we're going to stay for a few extra minutes to just cover those questions. However, if we don't cover yours, we'd be happy to answer either by email or even a 15-minute Q&A phone call scheduled for another time. I'm going to talk about that at the end. Also, this webinar is being recorded and it will be sent to everyone who's attending tonight. So don't worry about missing anything. You're going to have a chance to check it out again at your own convenience. Also, because we want to make sure that you're all paying attention, and because we also want you to have a little bit of fun, before we answer the questions, we're going to have a 10-question pop quiz at the end. And the first person to answer each question right inside the comment box, not the questions and answers of the Q&A, is going to win a $10 gift card to the store of your choice. And we'll be emailing back and forth. Rachel's going to keep track of who they are, and we'll be in touch with you to find out what your choice is. Now, there's 10 questions, so if the same person answers all 10 questions correctly first, then they're going to get a $100 gift card. So really pay attention, because we're going to have a little fun with that. Also, it's my obligation as a financial advisor and fiduciary to inform you that of our RIA's disclaimer statement, which is that our investment advisory services are offered through Fusion Capital Management, an SEC registered investment advisor, and we only transact business in states where we're properly registered or are excluded or exempted from registration requirements. SEC registration is not an endorsement of the firm by the commission and does not mean that our advisors have attained any specific level of skill or ability. And most importantly, all investment strategies have the potential for profit or loss. So now that we got that out of the way, I have only one question for you guys. One question. Why did the invisible man turn down the new job offer he got? Because he couldn't see himself doing the job. It's another one I stole from my older son, Case, when he was doing a show at the for the Cub Scouts a few years back. All right, I'll keep my day job. All right. So let's move on. So, welcome to our Understanding Estate Planning webinar. It's our second time presenting this topic this year, but since it's such an important topic and since we had those technical difficulties the last time as well, we decided to present it again to make sure that you all had the opportunity to take advantage of the great information that's part of this workshop. Plus, it's also a major bonus that we have again. We again have access to Rosemary and her vast knowledge on this topic. So we definitely wanted you guys to have the benefit of that again as well. That all being said, look, we have so much to share with you tonight, and we're going to provide answers to the most commonly asked questions on the topic, and also provide valuable information and perspectives in regard to the more basic aspects of estate planning. Things like, what's the difference between a will and a trust? What's included in each? What does a power of attorney do in regard to my estate? Will I need to appoint a guardian in my situation? What's the best way to structure my beneficiaries? I think you get the point. So this is a lot of important stuff, folks, and we all really need to figure out before it's too late. So on that note, let's jump in. So what is estate planning anyway? Well, estate planning is the process of reviewing your assets and belongings to determine how they're going to be preserved, managed, and distributed. Assets include things like real estate, cars, stocks, artwork, life insurance, pensions, and yes, even debt. Proper planning also considers the management of your financial obligations in the event you become incapacitated. For these reasons, estate planning is an essential component to your overall financial plan. It allows you to gain more control over various aspects of your life, both during your lifetime and after. I'm going to say this a few times tonight to stress the point, but please seek out the assistance of an experienced attorney in estate law to do this. It's absolutely essential to have your financial wishes fulfilled. A financial advisor like myself or someone else can help you to put a plan together to limit taxes on your estate, guide you through a process of the legal documentation, and even declare how your estate should be handled after your death. But I 100% advise you to seek out an attorney that specializes in estate planning like Rosemary to help you create and maintain a lifelong estate plan.
If I could jump in, Brian, it kind of is a pay me now or pay me later. You know, hire an attorney now to make sure it's done correctly, or your family's hiring an attorney later to straighten everything out. And that can be a lot more expensive.
Nothing could be more true. I mean, you always hear these nightmare stories. And actually, believe it or not, I lived one a little bit with my own mother when she passed. She didn't have these things taken care of. This is why this topic is kind of so, dear to my heart, because I was making trips down to City Hall. I got charged, all kinds of fees for things. It was trial by fire. So let's talk about a little about why many folks seem to avoid putting a sound estate plan together for themselves and their families. So one thing that you hear thrown around a lot when you're around this topic is something called cognitive dissonance. So let's define that. the state of having inconsistent thoughts, beliefs, or attitudes, especially as they relate to behavioral decisions and attitude changes. It occurs when a person holds contradictory beliefs, ideas, or values, and is typically experienced as psychological stress when they participate in action that goes against one or more of those things. Wow, that's a lot of words, right? In other words, it stresses people out. Nobody wants to think about it or talk about it. So, here's some interesting statistics. Here's a couple interesting statistics as it relates to it. For one, 47% of people say they need a will or a trust, but they haven't gotten around to it. However, another survey done by Merrill Lynch asked, how would you characterize someone who died without their affairs in order? Very interesting. 88% of the people chose words like irresponsible, inconsiderate, and ignorant to describe people that check out without their affairs in order. 47% said they haven't done it, but 88% of people saying, oh, they're irresponsible, inconsiderate, and ignorant to do so. Holy smoke, people are talking about themselves. What's your thoughts on that, Rosemary, when it comes to why you think people put this?
Obviously, nobody wants to think about death and plan for it. Some people even get a little superstitious about it. But and like I said, it's way easier to plan it. It's Ben Franklin said, we can avoid anything but death and taxes, and that's what we're talking about. So it's way easier to, deal with it yourself than let your family deal with it down the road.
And let me tell you, man, I dealt with it and it was a pain in the butt. And I know my mom, if she had known anything about it, wouldn't have wanted me to go through that. So it's a lot about what we're going to talk about tonight, everyone. So lack of urgency, that's another reason. So we all imagine that we have plenty of time to get our affairs in order. And most of the time, this is what leads to lack of urgency. Unfortunately, putting off estate planning places you and your family in a significant disadvantage in the event the unthinkable actually happens. In addition to this lack of urgency, many people feel intimidated by confusing jargon and the potential expense associated with estate planning. Some also fear the process will be emotionally demanding and time-consuming. And let's face it, some people just don't want to think about themselves dying, which just causes us to keep putting it off. So absolutely, along the same lines of what you're talking about, Rosemary, definitely some good reasons, but I guess we can all say they're all kind of in the same vein, right?
Right, absolutely.
So, all right, so let's say we've gotten over all the cognitive dissonance / plain old stress we feel related to this stuff. What are the main steps we need to take when it comes to creating our new estate plan? So when creating your estate plan, there are 5 major decisions you will need to address. The first is, who's going to get my assets when I pass away? Whether you wish to leave them to your children or gift them to a favorite charity or other loved ones, you're going to need to dictate that by naming your beneficiaries. That's the first step. Designating heirs for your assets is the main component of estate planning. Individuals and families who do not have an estate plan are at the mercy of the court when it comes to deciding who gets what. This process can sometimes take years and rack up tons of fees if it's complicated enough, and can get pretty ugly when it's not planned properly. I'm sure you've experienced a few of these things, right, Rosemary?
I'm thinking of one case where the gentleman had never married, no children, didn't have a will. I mean, we had a family tree that was the length of my dining room table because we had to go up to the grandparent level and then come back down. And, he had all sorts of cousins. It was, would have been a lot easier if he just had a will or, said everything goes to my church or my school or whatever, and we would have been done.
It's shocking too. At my old firm's office, they had up on the wall all these celebrities where it was nightmares after they had passed, and they never established anything for their wishes afterwards.
Well, we just recently, in the last couple of years, we had Prince,
Yeah.
we had Aretha Franklin, who I think they found a handwritten will under a couch pillow at her house, you know, so that's just no way to plan your estate.
Oh my gosh, no, and you know that's going to end up in court, right? I mean,
I think, I know Prince's case is definitely in court, you know, because they had to, all these people came forward and said they were his relatives, and I think there was DNA testing involved. So, you know.
I mean, you know, absolutely, and it's yeah, it's a little like, you know, you scratch your head, right? You're like, wow, these people with all this money and they didn't think of this. So, and it really surprised me with Prince too, because he was a pretty thorough guy when it came to his affairs, when it came to the music industry. But man, I was surprised they might. It's also, you know, Prince is Rachel's favorite of all time, right, Rach? Yep, and so obviously she's given me his history pretty much in detail over the years. She's seen him about 20 times. So yeah, that was a surprising one. The next decision you're going to need to make is what's going to be the method of distribution. This involves determining how your beneficiaries will receive your assets. So depending on the age or the financial capabilities of your beneficiaries, you may wish to delay distribution. For example, like you may stipulate that young beneficiaries receive their portion in stages rather than one lump sum. Some people designate specific portions of the assets to be distributed at a certain age or at various ages, just to take consideration of maturity. But there are really various reasons out there. That's probably one of the more common ones. What are your thoughts on that? Like, what have you experienced when it comes to this?
Yeah, traditionally, what we, you know, suggest with clients, especially with minor children, you know, yes, the guardian could hold the funds, but at 18, the child's entitled to everything be turned over. You know, so we usually are talking about trusts in that situation, where the parent can determine at what age or what ages the child receives anything outright. I mean, the traditional one is, you know, the child gets 1/3 at age 25, 1/2 at 30, the balance at 35. And in the meantime, the trustee is able to use the funds for the child's support and education and whatever. So it's not as if it's in a silo, but yeah, traditionally it's a kind of a 3-step process, but I certainly suggest to clients that at least make it 2 steps. I always figure if the child blows it on the first distribution, maybe they learned their lesson by the second, you know, and you don't want to hand a lot of money and a lot of funds to, you know, a young adult, even though at 18 they're considered an adult.
Are you telling me that an 18-year-old's not mature enough to handle $1 million? Come on.
Well, you know, I mean, you know, are they going to go out and buy the Ferrari instead of paying for college? You know, that's a question.
What I would look like if I got that money, got money like that at 18.
Would you still have had it at 19?
Exactly. Forget it. Would have been gone by the time I probably wouldn't have made it to 19.
Yeah. So we want to make sure, you know, there are funds there if, you know, God forbid the parents, you know, died prematurely, that there's funds there for college, you know, get the child started in a vocation, you know, maybe get the down payment on a first house. So, you know, we don't want it spent frivolously.
Well, and the other thing too is, just as a side note, there also could be tax implications to what age you do this, right? So,
sometimes with retirement stuff there would be, but not necessarily with a straight inheritance.
Right. Well, in some instances, I guess if they're not using beneficiaries on their accounts, and sometimes they use the estate, how does it usually work when you see it passing? Because there isn't federal tax usually, but there are usually some state taxes and stuff, right?
Well, the federal estate tax, an individual has at the moment has to be worth $11,700,000 to pay federal estate tax.
Yeah.
That probably is going to change over the next few years.
Right.
In Pennsylvania, we have what's called inheritance tax, which means the tax rate is determined by who the property is going to.
Right.
So there's no tax between spouses.
Right.
Any property that is going to a child or a grandchild is taxed at 4.5%.
4.5, that's what I thought.
Anything going to a sibling is 12%. And anybody else, friend, niece, nephew, godchild, that's 15% tax.
Yeah, 15%, right. Yeah, so absolutely. So I guess there needs to be some thought given to that as well. I suppose.
Yeah, I mean, we can, if someone's in the federal estate tax bracket, we can do a lot of planning, for that exemption. Unfortunately, Pennsylvania inheritance tax starts at dime one, so there's not a lot of pre-planning, we can do for that, short of, if someone wants to make a gift, and completely give away a particular asset or cash or whatever, that's going to lower the amount of their estate and the amount of the inheritance tax.
I know there is some creative things where they may give away certain assets and then convert into some life insurance or something like that.
Yeah, you could. Yeah, because life insurance is not subject to the inheritance tax.
So there is some planning that
there could be something along those lines. Sure.
Yeah, depending on how anal you are about that, but but certainly this is a big decision to make and should be done.
Mm-hmm.
Third decision is deciding who's going to be the financial power of attorney, your trustee and or executor, to make decisions for you in the event that you can't make them yourself. The person or persons you name should be someone who is responsible, especially financially, and is capable of handling finances for you, and is generally a good decision maker. Some people prefer even to name a professional trustee rather than a family member or a friend. Generally, we recommend naming 2 or 3 successors to that person, only because they could predecease you in some instances, and then you wouldn't you want to have a backup. Is that what you usually recommend?
Oh yeah, absolutely. We definitely, on power of attorney, you want to have at least 2 people named, 3 if you want. What I have found over the years is the power of attorney almost gets to be the emergency thing. Somebody ends up in the hospital, and we gotta pay mom's mortgage payment, and nobody has power of attorney to sign a check on her behalf. So that, unfortunately, if she's in the hospital and is unconscious or something like that, she can't sign at that point. So it's better to have this document in place on a just in case basis, and if someone would need it down the road. So that the power of attorney, I think people forget about.
Yep.
They know they're going to, a lot of people realize they're going to die. I need a will, but it's like, well, what if you're incapacitated? What happens then?
Yeah, that was one thing we did do right. So that's, and that helped a lot. Fourth decision is deciding what the person or persons will be to be your healthcare power of attorney. That can be either the same person that's the financial power of attorney or not. This is the person who will make healthcare decisions for you in the event that you cannot. You should appoint someone who can make decisions during difficult and emotional times, because that's usually what the situation is. The document also allows you to state your end of life and or organ donation wishes. So that would be part of it as well. Also recommending, do you usually recommend at least 2 on this as well? Or?
Oh, yes, absolutely. What if you're both in the same car accident? There needs to be somebody else in place. And again, this gets to be an emergency, obviously. Somebody's got to have surgery that, they're either unconscious, or with, some of my clients who've developed dementia, if they've got the healthcare power in place, at least, there's a family member who can make a medical decision for them, because they cannot do so themselves.
Absolutely. And the final decision, and this may not apply to everyone, obviously, but is to determine who will have legal custody of any minor children in that situation. So, your appointed guardian will work with the trustee to access funds for the care of your children. The best person for this is someone who will care for your children in a similar manner to yourself, obviously. And think about the values you'd wish to impart, and and the level of care that your children will need, Many people will appoint their parents, siblings, or in some cases, close friends. So, and again, another situation where you'd want to have multiple successors for the same real reasons, right?
Right, right. And then the guardian is the person who's going to decide where the child goes to school, you know, consent to medical treatment for the child, you know, what church or temple they're going to be raised in, if any, you know, making those kind of personal decisions, as opposed to financial. It's a different hat. It might be the same person who has the financial control for the child, but this, you know, it isn't necessarily the same person.
Yeah, I mean, this is a tough one sometime. When me and Rachel did this, it was tough. I mean, obviously, you know, age has to be taken into consideration as well, right? You know,
And I mean, you mentioned naming parents, you know, which is fine. You know, most people, you know, probably think their parents did a good job. They raised them. So this would be a perfect. Unfortunately, your parents are the generation above you. And so I don't say, don't name your parents, you know, but let's have a backup, you know, not even just that they're deceased, maybe just because of their age, they don't feel capable of chasing a 3-year-old, you know.
I mean, I imagine it's possible to even have some type of shared, you know, situation.
Sure, you can do, you can do something along those lines, as long as you figure everybody's, you know, gonna get along and, you know, cooperate with whatever the shared arrangement is.
Yeah, absolutely.
I mean, I certainly have had people, you know, say, you know, they want it included. Let's say they didn't have siblings to name. They name a friend. You know, okay, well, I want, you know, John Friend to make sure my children have a relationship with my parents, so that they're, you know, that the grandparent relationship is still maintained, but just they know the grandparents aren't capable of, you know, raising the children.
Full-time custody or
Yeah,
whatever.
yeah.
Yeah,
Mhm.
no, absolutely. It makes 100% sense. And it's certainly something, this is, you know, that's a little deeper at second thought than you might originally think. All right. So now that you have a better understanding of what goes on goes into estate planning, let's talk about the two major components that can facilitate its execution: wills and trusts. Let's begin by defining a will. A will, or a testamentary will, which is what it's called, because it's your last will and testament as a living person, is a legally enforceable document outlining how your affairs and assets should be handled after you die. A will is going to contain provisions which control or dictate to whom your property is distributed. While having a will is an effective way to transfer your estate and other legal proceedings following death, you should be aware that your estate will become part of the public record. This is because anything left via a will must go through probate court. Unlike retirement accounts and life insurance policies, which pass straight to the named beneficiary. Again, I can't stress this enough. In order to create a legally binding and comprehensive will, you should definitely seek out the assistance of both an experienced financial expert and legal counsel who understand the fine points of doing these things. So, what do you want to give a little more background on a will? Is there anything else you wanted to add to that?
Well, we're usually using just direct distribution wills when we're talking, you know, not federal estate tax level estates, you know, of 11 million and more, you know, maybe if, and all the children are adults and everybody, you know, is financially stable and mature and no substance abuse issues or mental health issues or something like that, you know, then a will is, you know, perfectly fine. I mean, certainly with some younger couples, maybe who have minor children, you can have a trust created within the will. You know, you don't have to have a standalone trust. So that a lot of times we're using that, but the trust is more of a long-term situation.
Right.
You know, with a will, when the person dies, it's filed with the Register of Wills office. The executor collects the assets, pays the bills, pays the taxes, and then the executor's job is done because they turn everything over to the beneficiaries. Okay, with a trust, the trustee is maybe, like I was saying, holding these funds till the child turns 35 years old. So it's a much longer possible process involved.
On that note, actually, and then to get a little into that more, a trust is another method of estate transfer.
Yes.
There are many types of trusts to choose from depending on the function you wish to carry out. For example, there's special needs trusts,
right,
revocable trust, irrevocable trust, asset protection trust, charitable trust, constructive trust, spendthrift trust, tax bypass trust, etc. I think you get the point. And like a will, a living trust will require you to transfer property after death to your loved ones. It also is known as a living trust because it's created while the property owner, also known as the trustor, is still alive. As the trustor, you can make changes to the trust at any time while you're still alive. However, unlike a will, a living trust passes property outside of probate court, which means your assets can be passed directly to your named beneficiaries without court involvement holding up the process.
With one caveat there.
Throw it in.
The property has to be in the trust before you die to avoid the probate process. So a lot of times with these living trusts, the grantor, the person who's creating it, they transfer their funds or brokerage accounts or whatever into the name of the trust. They're the primary beneficiary at that point. So everything, is for their benefit. They can pull it out, they can sell, buy, whatever they want to do. But the property's got to be in the trust to avoid probate at their death. So it's not just, oh, I've got this lovely trust document. You have to do something.
Yeah, let's talk about that just for a second, though, the types of things that go into a trust. Now, first of all, I know that retirement accounts are not in trusts, right?
No, we want those to go directly to the beneficiary, unless there's some reason like the only beneficiaries are minors, then we might name the trust.
And life insurance usually isn't either, right?
It's usually a what? I'm sorry.
Life insurance?
Is usually I didn't hear that.
Not in the trust?
No, we wouldn't necessarily transfer ownership of the policy, but we can name the trust as the beneficiary to get the proceeds into the trust, at death.
Right. And it's the same thing with those, with the retirement accounts, right?
Yes. Yeah, you don't transfer the ownership. You would just name the trust possibly as the beneficiary, depending on who the beneficiaries of the trust are.
Right. Okay.
Usually, especially if there are spouses, you're gonna name the spouse as the primary, primary
Right,
beneficiary.
exactly. No, absolutely, it's the primary, of course.
Mm-hmm.
But things like a home, brokerage accounts, things like that, savings accounts, bank accounts, any of them, CDs, all that stuff can be in a trust, right?
Yes, that's correct.
Exactly. They're not made the beneficiary. It's actually in the trust, right?
It's owned by the trust, but during the person's lifetime, it's all still reported on their 1040. The trust, the accounts, like with you, would still have the person's social security number on it. Wouldn't be a separate tax identification number. So you have a document, you have a trust or a bank account that says the Rosemary Durkin Revocable Trust, but it's under my social and it's reported on my 1040. So until I die, nothing really changes except the name on the account.
Absolutely. You still have, complete control over the
right. Absolutely.
Absolutely. So it's just a subtlety that I think a lot of people, they might get a little confused with. And here's another thing. I know that you got to be careful, right, these days, putting putting real estate, your home into a trust as well, right?
Yeah, there can be Pennsylvania transfer taxes depending on who the beneficiary of the trust is. So we want to be careful on how that comes about and whether or not we can transfer it at all.
Yeah, I mean, I had a client, it wasn't worded correctly, and she got charged the transfer tax and wasn't very happy. All right, so let's so there are some noted similarities between a will-based plan and a trust-based plan. First, both a will and a trust allow you to control who gets your assets at your death, how those people or entities get your assets, and who's in charge of making the financial decisions at your death. Second, both the wills and revocable trusts can be changed provided you have the mental capacity to do so. Also, both documents are set in stone upon your incapacity or your death, meaning no changes can be made once you are either declared incapacitated or you've passed. So, I mean, did you want to add something to that in terms of the similarities? Or is that kind of
No, that was pretty much, that's pretty much, the similarities. That's good.
As far as the differences are concerned, so first, a trust will avoid probate, like we talked about, if funded properly. So I'm not really sure what that means, if funded properly. Your thoughts on that?
Well, like I was saying, if the brokerage account's been transferred ahead of time, if the bank account's been transferred, then it's in the name of the trust. So then it's done. The transfer has been taken care of.
So if
And the executor doesn't have to do it
the
himself.
transfer aspect is taken care of, correct?
Right.
Okay. So then it's unlike a will, which is created in order to tell a probate court where your assets should go. This doesn't go to probate. So it's actually dictating the process on its own. So is that a good interpretation?
Yeah, absolutely.
Okay. On that note, in some states and situations, probate can be pretty costly and it can be time intensive, and most documents are public records. So that meaning that anyone can show up to find out what's going on and to find out who's getting what. Is that pretty much an accurate depiction of it there?
Yeah. The wills are maintained as public record. So that has, you can get a copy of someone's will. The other thing on the fees, Pennsylvania is one of those states. Pennsylvania's fee at the Register of Wills is determined on the value of the estate, whereas opposed to just a flat, $200 or $300 or something, which a lot of other states will charge. Pennsylvania wants to know the value of the estate, an estimate at least, when you file the will, because that determines the fee. When you eventually file the inventory, if it's a much greater estate, you're going to get a bill for whatever the additional fee is. So Pennsylvania can be expensive. And that's just the Register of Wills. That's different from the inheritance tax that I was talking about.
Well, I know exactly what you're talking about because I couldn't believe it when I got that bill.
Mm-hmm.
I was like, what the heck is this? So yes, absolutely. And guess what? That was for a car that had a loan on it.
Yeah, but it goes by the gross.
Right. It goes by the fact that it's an asset and the value of it. They don't care if that person owed money on it or not.
Right.
So it's important. Ending up down there is not that fun. So also, again, if done properly, trusts are far easier to administer and are completely private in nature, while wills become, like we said, public record and could take years to distribute, especially when they're contested in any ways. And really, that's
if they're obviously if there's a contest, and you can have a contest over a trust too, but but obviously any sort of litigation is going to prolong the estate administration. When it's a basic will, we usually don't have any sort of issues. We can take care of the administration certainly within a year. A lot of times it depends on, if there's a house to be sold, sometimes just that holds it up, and that's really not the probate process. That's just getting a house sold, you know,
Oh,
so,
yeah, I mean, of course, I mean, depending on the house, it could be easy or hard to do that, right? So,
right, yeah, depending on the condition or whatever.
yeah. So again, a trust more comprehensive than a will because it allows you to control both what happens now while you're still alive, if you become incapacitated, and what happens upon your death. And so, while a will, on the other hand, only controls what happens at your death, right?
Yes.
Okay, so, all right. So, why do I need a will? So, when you have a trust-based estate plan, you also have a will that goes along with it. And that's important because if you did not put all your assets into your trust, the will would then govern at your death where all your assets will go. And that's what you were talking about, making sure that everything was transferred right?
Yeah, right. So, you know, if we do prepare a living trust for a client, we're still preparing a will. We call it a pour over will because it pours over into the trust. You know, because there's usually something somebody forgot to transfer, or like I have said in the past, you know, you win the lottery the day before you die, you know, somebody's got to get the lottery proceeds into this trust. So, you know, so there's always going to be a will. Now, I certainly have had, you know, clients who have a pour over will and a trust, and maybe they did get to everything transferred and there's nothing else that has to go through probate, and then we just don't file the will. We just take care of the trust, you know, and maybe their IRA goes to their surviving spouse or goes to whoever, so that's outside of probate, and the life insurance goes to a named beneficiary. So we still might not be doing anything with the will, but we still want to have it there just in case.
Just in case, right? And then on top of that, in a number of states, the will is the primary place where you can name guardians for your minor children, right?
Yeah, certainly in Pennsylvania, New Jersey, that's where the guardian has to be named, is in the will. So you could be filing the will just to name a guardian.
Yeah, you could have the will just for that purpose, right?
Yeah. I don't think I've ever actually done that, but that's certainly possible.
Yeah. So what if I've named beneficiaries? So if you have named beneficiaries on assets, life insurance or retirement accounts, for example, the beneficiary designation controls and supersedes your will. This is why it's important to make sure your beneficiary designations are in line with your estate plan. And this is something I'm always talking about with my clients, you know, and I believe it or not, in the course of a year, I deal with changing beneficiary designations a dozen times, maybe, various kinds, you know what I mean?
Yeah, no, please make sure your beneficiaries are up to date, especially of retirement money. Because if you don't have a named beneficiary, it's got to be paid to the estate, and the retirement money is going to come out at a much faster pace than it is if it's paid to an individual. So, you know, I've had people, you know, I had one gentleman, unfortunately, you know, started to work for the state of New Jersey right out of college, and unfortunately had a massive heart attack in his early 50s with a wife and 3 children. And his parents were still the beneficiaries on his retirement money with the state. You know, now everybody signed off, but it was not a good tax effect at all.
Right.
You know, so, you know, please, even if you think, oh, I took care of that, if you haven't looked at it in a couple of years, go back and look at it and make sure.
Absolutely. It's I had a guy in one time, his brother passed, and there was the beneficiary that he had on there had passed, and it went through, it was a couple of years before he was the only next of kin. And, you know, the guy didn't realize it when that other person passed to go do it and change it. He went through hoops.
Yeah. And you're going to pay a lot of income taxes because, you know, if it's retirement money.
Yes. And he got hit hard with the taxes. Absolutely. Wanted it all up front. So in most cases, so you're trying to figure out which is the right one for you. In most cases, if you're trying to space out distributions for your beneficiary, such as minor children, avoid probate, you're trying to avoid probate, and you want to exercise more control, you should consider a trust-based estate plan. Would you say that's accurate?
Yes, absolutely.
Now, on the other hand, if all your assets are passing by beneficiary designation, and there's no reason to hold things back from your adult beneficiaries, a will-based estate may just get the job done instead, right?
Yep.
So it could be that.
I mean,
easy.
every client's different. Every client that walks through the door, some just, I don't want to say just, but some people, a basic direct distribution will is just fine, but obviously minor children or a beneficiary with special needs, or a beneficiary who's a spendthrift or has an addiction problem, then we're talking trusts or, some other vehicle.
Absolutely. The more complicated it is, you're probably going, you err in the on the side of caution with a trust-based estate.
Yes.
Okay. Review of your existing estate plan. So just like a review of your financial plan on an annual basis, it's recommended that you review your circumstances surrounding your estate plan on an annual basis as well, or at least when life events occur, such as like births and changes of marital status, or really anything that happens that may affect your final wishes. However, though, some noted times that you should consider making changes to your will or trust are, one, say, changes to your health or wealth, relationship changes to your power of attorney or trustee or guardians, real estate changes. And this is a big one here, tax law changes. Some old trusts sometimes have language that can increase taxes on beneficiaries. Have you seen any of this kind of stuff?
Oh, we've sent letters out to clients, I think every time the tax law changes, to say, hey, this is going to affect, your plan. Because a lot of, especially people involved, who are dealing with possible federal estate taxes, a lot of the language refers to the Internal Revenue Code, and is based on that. And if that changes, it's going to throw everything off. It's, it's definitely, and I don't know how many tax law changes there've been in the last 10 years, but, certainly there's been quite a few, at least at the federal level. New Jersey abolished their estate tax several years ago, I think 2012. And there are a lot of plans that are still out there that, because people didn't get around to changing them, that are based on New Jersey law, which, is not, that law is not effective anymore.
We might be looking at some new ones soon too.
Oh, well, the President Biden has introduced something, or at least, is pushing something. I don't know if it's actually gone to a committee, but, and Jersey, looks like Jersey might bring back the estate tax. Pennsylvania, I haven't heard anything about any sort of changes to the inheritance tax, but hey, stay tuned.
Yeah, you just don't know, obviously. So yeah, there are certainly times, and that's a big one to consider, and probably the most frequent one, of these. So definitely food for thought there. So, why is estate planning so important? So, folks, estate planning is all about protecting your loved ones. The primary benefits of estate planning include things like the ability to choose who will inherit what among your possessions and valuables. It affords you the chance to name your children's guardian in the event of an unexpected death. It could be reducing taxes on what you leave behind. And also because it minimizes the chances of your family, of a family strife or any ugly type of legal battle. So we hit on some of them already, but obviously any others you can think of that drive the point home, or?
No, I think that covers it. I mean, it's important to, it's not for you. Estate planning is not for you. You're going to be gone, but it's for the people you leave behind. And, so it's something that is important to be taken care of.
Absolutely. So it's basically leaving a roadmap. So they say in life, you should always have a backup plan. The same is true after you die, really. This is why we recommend several backup trustees. And, estate planning is the only way to ensure your final wishes are actually carried out. And when it comes to your assets and your family, so you're not really leaving anything to fate. Look, grieving over loved ones is stressful enough in these types of situations. So having a plan in place that allows your family to focus on what matters during those difficult times, rather than trying to decipher what your wishes may be. And I'll tell you, another thing coming to mind that happened when my mother passed was, although she had mentioned things to us here and there about services, these types of things. I mean, do you ever experience people putting things like that in these things, or?
We don't put it in the will because a lot of times the family doesn't go to look for the will until after the funeral. You certainly can prepay your funeral and make your own arrangements first, or, just really, if you have something, specific you want, just write it down and let, your family members know about it.
Right.
Maybe, there's a document out there. I forget the name of the organization, but the document is called the 5 Wishes.
Mm-hmm.
And it's a living will. You can specify, I want a DNR order. I don't want dialysis, whatever end of life decisions you want to make. But it also has space in there, if you want to write down the hymns you want at the funeral, the readings,
what you want to wear,
what minister, what priest, what rabbi, whatever, and people do have, thoughts and whatever. I remember one client, he wanted Danny Boy's son at the funeral. So we made sure Danny Boy got son, so.
Yeah.
So if you have a preference on that, let your family know.
Yeah, absolutely. I mean, so really more often than not, families who don't have a will or a trust many times fall into disarray, sometimes even go into battle over what they think they deserve from you, right? I mean, this is not that all that uncommon, right?
No, not at all. I mean, this is America. People can fight over anything and sue you for anything. But, a lot of times it's more chaos if there's no will involved.
Absolutely. So,
Mm-hmm.
Believe me too, that type of strife can damage relationships. And I've seen it, relationships permanently in some cases with family members.
Mm-hmm.
You're just really trying, if you can, avoid all that.
Right. Absolutely.
So, bottom line is, if you want your assets and your loved ones to be protected following your death, you're going to need an estate plan. Without one, your family could not only be left dealing with a lot of extra stress and personal challenges like those we just mentioned, but in some cases could also be faced with significant tax burdens as well, like the guy I was mentioning who wasn't on the beneficiary form.
Mm-hmm.
And to top that all off, without a directive from you, the courts would end up designating how your assets are divided, and maybe even who gets to raise your children, if that applies to the situation. And that would be insane. I'm sure you've experienced that, right?
Oh yeah, you can definitely have a fight over who's going to raise the kids. If you got 2 sets of grandparents, way better if there's a will saying, which grandparent, which friend, which cousin is going to be the guardian.
Yeah. And, so as you're pondering this topic, just please keep all these things in mind. Rachel is going to copy and paste all the notes from this material into our comment box, if anybody wants that. Yep. This really concludes the learning part of our workshop for today. And I hope that you were paying attention, because this is when things are going to get kind of fun and interesting.
I think we got a couple questions in the chat, Brian.
Okay. Now, before we get into the questions, I want to just run down this quiz and then we're going to answer the questions. Is that okay?
All right, that's fine.
Okay, so you got a hold of this, Rachel? You got a notebook? Okay, so question number 1. What is the short definition of cognitive dissonance? The short definition, not the long one, the one I said at the end, the short definition. Anybody got it written down? So you want to unmute, read us the answer?
Yeah, it looks like Larry Krasley answered first.
Okay.
Says, let's see, contrary beliefs. What's the first answer?
Yes, that's part of the long definition. But the short definition is it just what people out.
Let me see, we got Michael Alba, stuff that stresses you out.
Exactly. Stuff that just stresses you out. You don't want to think about it. Larry, you're too smart. You know that? You answer, you remember everything. Larry's one of my kind. Okay, second question. We got Mike Alba on that. You're gonna have to send us, Mike, your store of choice for a $10 gift card. Second question. What is the first decision in building an estate plan? Remember I said there's 5 steps? What's the first step? You got to choose who? All right, what do we
All
got?
right, Larry Krasley says defining beneficiaries.
Who said that?
Larry Krasley.
You got it, Larry. Good one. So he won the second one. Good job. Okay, third question. Getting a little harder. What is the third step or decision in building an estate plan? The third one. Is it like
Yeah, you need some music, Brian.
yeah. What's that show again? Is it
Let's see, is it Amphy says method of distribution?
that's the second.
Okay.
Good one. That's the second. You're choosing. Ooh, I want to give it away. You're choosing somebody. What's that person called? Come on.
Let's see, Mike Alba says trustee.
Trustee. Yeah, it's one of them.
Is that it?
Right? Power of attorney, financial power of attorney, trustee, right? And now I'm trying to, what's the other one, Rose?
Guardian.
The guardian was the last one, but the trustee,
Was it? Okay.
the trustee, the financial power.
Executor.
Executor.
Yes, executive.
Yeah, we got that one there.
All right. You got that one? So yeah. Who did that go to?
Which answer were you looking for? Executor?
Whoever, executor is one of it. Trustees also one. It's all part of
Okay.
the same one. And financial power of attorney. Is that all the same person there, Rose, or can that be all different people?
Cannot be all different people, could be the same person. Or two out of 3. You know.
2 out of 3. So who was the first one to say of them?
Let's see. We got Mike Alba got trustee. Looks like Phil got executor, and Deb Poole put in power of attorney.
Well, power of attorney was the first one. That's a tough one. Mike got the first one. Mike, you already won one, right? So we'll have to, I think, give it to the second person. Who was that?
Phil
Phil?
H.
All right, Phil, you won. You won that one. All right, so now, what are the two major components of an estate plan that are used to give directives and dictate how your wishes and assets are transferred? The two major components. We talked about them pretty much throughout the whole thing. Larry Crosley. Larry got one. Who was the second one?
Ann Fee.
Ann Fee. All right, we're gonna go with Ann Fee on that one. Hope you're okay with that, Larry. You're quick to the trigger. Okay. Thank you on that, Ann. Which component can only be used after death? Of those two, which one can only be used after death? Or is only applicable after death? Wills. Is that Larry?
Yeah.
All right. And no one else? Oh, well, Larry, we're gonna have to give it to Larry. All right, Larry, you're in for two. Sixth one. Which component can be used before and after death? Trust and fee. Good one. He was the first one. I guess we're gonna give it to Ann. That's two answers, Ann. Good job, Ann. All right. Number 7. Are there more differences or similarities between wills and trusts? So more differences or similarities based on what we talked about? Differences. Deb Poole. Good job, Deb. All right. I thought that was a little hard, that one. All right. Between both a will and a trust, which bypasses probate? And fee again.
Smarty pants.
All right, I guess we're gonna have to give it to Ann. Man, you're really racking them up, Ann. Between both a will and a trust, which does not allow for a private process. Yes, Deb Poole. Probably Deb and Bob right there, I'm pretty sure, right? Good job. So we got Deb in for 2. All right. Last question. Who can you call for a 15-minute Q&A session in regard to all this information? Who can you call for a 15-minute Q&A session to discuss this information? Me! That's right, Phil. Good job. And good job. You got it. All right, there you go. There's our winners. We're going to be in touch with everybody. We have your email and numbers to find out where you'd like your gift cards to be from. And at this point then, so now let's dig into a couple questions. What do you got for us, Rachel?
Hold on. Hold up. Okay, so there's a few in the Q&A here. It says, is an advance directive the same as a living will?
A living will is a type of advance directive. The advance directive is kind of the general term. You could possibly also have a healthcare power of attorney, you know, or sometimes some attorneys will put both of those in one document. So the advance directive is the general term. Basically, a living will is an advance directive.
All right, what do you got?
And there's another one here. It says, is a durable healthcare power of attorney that I get from my healthcare provider a legal document?
I would tend to doubt that you're getting a healthcare power of attorney from your medical provider. What you may be getting is a Hipaa form, the Health Insurance Portability Act. It's the Privacy Act. At least that's what I get from my doctor. I don't get, I've never been offered a healthcare power of attorney. But the Hipaa form is allowing the provider to release your medical information to whoever's named in the document. Not that those people are making medical decisions for you, but that they have access to your medical information. I mean, like, I think every time I go for my checkup, I get the Hipaa form and, I put down my husband's name, so if he has to call the office or whatever, he can have the information released to him. So I would tend to doubt that, that a healthcare power, that you can get one from your medical provider. So you just need to make sure what document you're looking at.
Okay. All right. All right. Do we have time for a few more, Brian?
Yeah.
Okay. So just a couple more. If I want to leave details related to my funeral services, do I do that in a will or in a trust?
We just talked about this, yeah.
I would not do it in either document. I would do it in a completely separate document that you can call funeral instructions or whatever, because a lot of times the family doesn't go looking for the will or the trust until after the funeral. So I think it's something you need to do ahead of time if you have specifics you want taken care of, and make sure that, the person or persons who will probably make funeral arrangements, have a copy of that. But that isn't necessarily a document you need an attorney to draw up. That can be just a letter saying, I want eagle's wings at the funeral, whatever. It's not a required, doesn't have to be witnessed and notarized and that type of stuff.
One more, Rach.
Okay. Well, let's see. How about how can I make sure that my children pay the least amount of taxes when they receive my money?
You can give it to them ahead of time if you have enough money to go around and you don't need it. Okay, if you make gifts and live a whole year afterwards, there's no Pennsylvania inheritance tax. People usually don't want to do that. They need their funds to support themselves. There's, like I said, there's not a lot that can be done to avoid the Pennsylvania inheritance tax. We can do stuff where you make gifts to children or make it to an irrevocable trust, so it's completely out of your estate. So there are some things like that, but, there's not a lot, that you can specifically do with to avoid the Pennsylvania inheritance tax.
The one thing, like I mentioned, kind of creative financial planning, you do see sometimes of people who are really like, trying to make sure they're paying the least taxes. So once in a while you see people set up where they give their assets to charity, but they'll use certain amount of their assets to pay for life insurance to maybe equal to the amount of whatever assets they would have gotten to their beneficiaries, and then they would get it tax free. But I mean, that's kind of like creative planning. I think
that's it's a little more creative and not illegal. It's just a little more creative than some people want to get into.
Yeah.
And it also depends, whether the client's insurable. Well, you always have that consideration.
Yeah.
But the life insurance is not going to be subject to the Pennsylvania inheritance tax. So life insurance, even if not necessarily get into a charitable thing, Brian, but if somebody buys life insurance figuring, okay, the brokerage account's going to be taxed, the house is going to be taxed, but here's a life insurance policy, you're going to get cash that kind of replaces the amount that's going to get paid to the Department of Revenue.
Yeah, sometimes, that's done too. They get life insurance just to pay the taxes. So, there are some creative things that can be done. It's just, depends on how bad the client wants to do it. You don't, like you said, see it so much. So, All right, so we're going to wrap it up. Well, folks, so I hope you found a great value in this information today. I want to thank you for taking the time to learn more about creating your estate plan. While making plans for your assets and wealth after death isn't anyone's definition of a super good time, the alternative, it can be far worse. So remember, you can save your loved ones from logistical and emotional nightmare by putting your wishes in writing today. Also, if you have any questions, either for myself or Rosemary about the information in this webinar or in general, we'd be more than happy to discuss them with you and to help you get started with your estate planning as soon as you're ready. In fact, for being part of this webinar today, I'm extending out to everyone on a complimentary 15-minute Q&A phone conference. Rachel's going to put in the chat box a link that goes directly to our website where you can schedule that. And also, too, if you go to our website, you can do it there as well. It's at plcfs.com. That's Paul, Larry, Charlie, Frank, Sam, plcfs.com. And you just click on the Book Now tab at the top right side of all the pages on the site. You can also call me, Brian Dougherty, at 215-804-9708. And I'd be more than happy to discuss these things with you. Also, I'd be also more than happy to facilitate bringing Rosemary into the mix if the situation calls for it at that. So I absolutely love the way Rosemary does things, and anybody who's that we discuss things with that needs any of the types of services we talk to, that we believe Rosemary is the person to go to for that. Be happy to bring her into the mix with that. That all being said, before we part ways, I'd like to thank our special co-hosts for this event, the esteemed estate planning attorney from the very popular local law firm Stark & Stark, Rosemary Durkin. Thank you.
Thanks, everybody. Thank you, Brian, for having me.
Absolutely, so much. It was awesome doing this. I hope you'll come back and do it again at some point.
Well, we'll see what's going on.
We'll see about maybe next year, right?
Yeah.
And our moderator for it, my wonderful, beautiful partner in business and life, Rachel Dougherty. Folks, have a great week. And we hope to see you next month on Tuesday, October 26th, where we're taking on the topic of Social Security disability and the basics of Medicare. See you all then.
Thanks, everybody. Have a good evening.
Night.